All right. Hello, everybody. We'll give it 10 seconds to allow all the slackers to join. All right. Hello, everybody. My name is Nick Altman. You've joined the Colorado Division of Real Estate's HOA Information and Resource Center's August HOA Forum. The topic of this month is pre-CCIOA communities, and I think this will be a good presentation. I think we'll learn a lot. At least I know I have. It's certainly not an easy topic to understand, but I've tried my best to hopefully convey it to you in a way that's informative and maybe makes a little bit of sense here. But yeah, let's let's get into it. My name is Nick Altman. I'm the HOA Information Officer. My colleagues David Donnelly and Amanda Lopez have also joined me on this call today. David, if you guys want to pop your videos on and say hi real quick, up to you.
Good afternoon, everyone. Thank you very much for joining us today on this exciting topic. And as Nick indicated, also a very dense, thick, complicated topic as well. So thanks again, and a good way to finish out the week and come into a holiday weekend.
Yes. And piggybacking off of that, yes, happy Friday to everybody, and thank you so much for joining.
Okay, thanks, David and Amanda. So, legal disclaimer, as always, the information presented in this webinar should not be construed as legal advice. It's intended for educational purposes only. If you have any legal questions, please consult with a licensed attorney, preferably an attorney who's experienced in the world in the realm of community association law. There's a lot of different attorneys out there, and they specialize in a lot of different areas of the law. So be sure to do your due diligence when communicating or working with an attorney. What the HOA Center does, we provide information to homeowners regarding their basic rights and responsibilities under CCIOA, which stands for the Colorado Common Interest Ownership Act. We gather, analyze, and report information through HOA complaints submitted by members of the public. We also maintain a database of HOAs in the state. Currently, we have identified a little over 11,000 HOAs, about a little over 8,000 which are actively registered, and the remaining which are either expired or potentially just have not registered. We also create resource materials and education materials such as what you're watching right now. We do have a website with information available to the public. We publish an annual report, usually around March or April of every year. Yeah, so what the HOA Center does not do is we do not act as a regulatory program. That's not authorized per statute. We do not mediate or arbitrate. We can't provide legal advice, or we also do not, or we try our best not to act as an advocate in a dispute between a homeowner and their association or their community manager. We do not have the ability to assess fines or penalties. And we do not enforce an HOA's failure to register. If you are interested more about this office and what it was statutorily created to do, the specific section is 1210-801 of the Colorado Revised Statutes. So to help with this topic, I thought it'd be useful to start with a list of definitions that are relevant to CCIOA and state law and pre-CCIOA communities. Beginning with association or unit owners association. So there's no actual legal definition of HOA in Colorado. Instead, we have the state law, CCIOA, and CCIOA has its list of definitions, including association or unit owners association. And CCIOA, of course, it directs you to another section of CCIOA because why can it ever be simple, right? But it's a unit owners association organized under section 301. And when I say section 301, now and moving forward in the presentation, I mean section 38-33.3-301. So association or unit owners association typically is created after a common interest community is formed or a declaration is filed with the county clerk and recorder's office. There may be instances where you can have a common interest community, but not a unit owners association. But I am not familiar with any of those, or how I don't think it's super common, or if it does exist, it's exceedingly rare in Colorado. But 103 would have some more information on the creation of a unit owners association. So the next definition is, of course, a common interest community, which is defined by Kiowa as real estate described in a declaration with respect to which a person, by virtue of such person's ownership in a unit, is obligated to pay for real estate taxes, insurance premiums, maintenance, or other improvements associated with the real estate that's described in that declaration. So if you have a question whether you reside in a common interest community, the first step should be to check to see if there's a declaration, a filed declaration with your county clerk and recorder's office, whether there's real estate described in that declaration, and whether your neighbors or other unit owners are obligated to pay for shared expenses to maintain or improve that real estate. When I say real estate, typically that means like common elements, or maybe perhaps a swimming pool or sidewalks or roads owned by the association, things of that nature. So basically there are three types of communities that we should sort of consider here when we're talking about Kiowa and common interest communities. The first is condominium. And a condominium, I know it's kind of a long definition. Essentially, here it says a common interest community in which portions of the real estate are designated for separate ownership, and the remainder of which is designated for common ownership solely by the owners of the separate ownership portions. In layman terms, a condominium is a community in which the unit owners own the common elements. So I'll say that again. A condominium is a community in which the unit owners own the common elements, as opposed to the association. A declaration is any recorded instrument, however denominated, that creates a common interest community, including any amendments to those instruments, and including but not limited to plats and maps. So again, this is a legal document that's binding. When you purchase a property into a homeowners association, you should be given this important legal document when you buy your property, and it'll set forth all the rights and obligations of the association as well as the unit owners. And again, this should be filed, executed with the county clerk and recorder's office. It even goes as far as requires certain Kiowa communities require the signatures to be notarized by the owners of the real estate. Large planned community, this is one exemption that I'll talk about soon, but basically it's a planned community that meets certain criteria set forth in Kiowa with respect to the size of the community, the number of units, and amount of acreage that the community encompasses. When I was speaking about condominiums earlier, here's a definition for planned community. So that's like the second type of community that we're primarily interested in here in Colorado when we're talking about Kiowa. So a planned community is sort of a catch-all. So it's essentially a common interest community that's not a condominium. And a cooperative would be the third type of community that Kiowa defines, but there are not too many cooperatives in Colorado, and we don't see too many issues with those, knock on wood. But primarily, we're interested in condominiums and planned communities in this presentation. So when I mentioned condominiums where the unit owners own the common elements, in planned communities, the association owns the common elements. So that's an important distinction there. Okay, so kind of as we're considering whether the type of community that we reside in, whether it's considered a common interest community or not, at least for declarations that are recorded on or after July 1st, 1992, but these are considered quote unquote post-CCIOA communities, most newer communities that are developed today. The declaration must contain the following information. The names of the common interest community and the association, and a statement that the common interest community is either a condominium, a cooperative, or a planned community. So if there's any hesitation or doubt, if you're at a board meeting or talking with a neighbor and you're just not sure, your declaration must contain a statement, identifying what the community is, whether it's a condominium or planned community. It's not always easily distinguishable. Sometimes you might have like a townhome community or a multi-unit duplex type community where it's not entirely evident whether it's a condominium or planned community. So therefore, look to your declaration to determine what type of community it is. So these declarations must also contain the name of every county in which any portion of the common interest community is situated, a legally sufficient description of the real estate included in the common interest community, so a description of the common elements and all the real estate that the association owns, a statement of the maximum number of units that the declarant reserves the right to create. And this can all be found at section 205 of CCIOA. It also must contain a statement for condominiums or planned communities, a description which may be by plat or map of the boundaries of each unit created by the declaration, in addition to including that unit's identifying number, or in layman's terms, just the unit, the condo, the apartment. I'm not going to say apartment, the condo number or the street address of the unit, some kind of identifying number that says that this unit exists. Description of any limited common elements. I underlined this next one because I thought it was particularly important. An allocation to each unit of the allocated interests. So this means the declaration has to contain a formula or some sort of calculation as to how dues are allocated to all the unit owners. So you can check that formula, you can check that calculation to determine, hey, does neighbor A pay? Perhaps they pay a little more every month because they have greater square footage or more bedrooms in their unit compared to neighbor B, or perhaps there might be some other formula that the association uses to determine how assessments are divvied up among the unit owners. The declaration for these newer communities also must contain any restrictions on the use, occupancy, and alienation of the unit, and I primarily take this one to mean the owner's ability to lease out or short-term rent their units. So those restrictions, if any, must be found in the declaration. The recording data for recorded easements. So any ability of one unit owner or the association to traverse across somebody else's property without their permission. I think that's my understanding of an easement. It has to be identified in the declaration. Reasonable provisions concerning the manner in which notice has to be given to unit owners concerning operations and collections governing the community. And if it's a if your community is one of the large planned communities that are defined in Kiowa, that a statement, if applicable, that the large planned community, that it is a large planned community and that is exercising certain exemptions from Kiowa, set forth. So, kind of more broadly speaking, so Kiowa is codified in Article 33.3 of Title 38 of the Colorado Revised Statutes. If you were interested in reviewing this law yourself, you can visit the Colorado General Assembly's main webpage, and I believe if you go to the laws dropdown, and select Colorado Revised Statutes, CRS, and log into their system, you should be able to view an entire catalog of not only Kiowa, but all the articles and titles of the Colorado Revised Statutes. So Kiowa is not the only relevant law that applies to common interest communities. You also have metro districts, which I believe is Title 32. There's also a very broad area of law focusing on foreclosure actions and selling foreclosed properties at auction. I don't know off the top of my head which title that is, but if you're interested, you can just send me an email and I'll send that over to you, no problem. So in addition, as we're thinking about Kiowa here, common interest communities created before July 1st, 1992, which are considered pre-Kiowa communities, are still subject to an older law called the Condominium Ownership Act, which is Article 33 of Title 38 CRS. It's actually precedes right before Kiowa. It's the section of law that's right before, I think it's section 101 of Kiowa. Okay, let's see. So I kind of already went through this. Kiowa is a set of laws that govern the formation, management, powers, and operation of common interest communities in Colorado. I think it's important to also realize and consider that even if you're a pre-Kiowa community, like a community that was created before July 1st, 1992, your community will still be subject to most of Kiowa. A large chunk of Kiowa will still apply to your community. It may be argued whether it's how important those provisions are that are not included in pre-Kiowa communities, but hopefully as I get through this presentation that I'll be able to shed some light on that. So I've already defined pre-Kiowa communities. So essentially it's a community who's, well, this is slightly different, whose declaration was filed prior to July 1st, 1992. Essentially was the community created prior to July 1st, 1992. In order to create a community, you have to file a declaration, common interest community. So again, most provisions of Kiowa will apply to pre-Kiowa communities. There is a long list, and I'm not going to bore you to death with every single statutory citation, but I picked out what I believe to be some notable inclusions that do apply to pre-Kiowa communities. And that's on this slide here. So for pre-Kiowa communities, notable inclusions of Kiowa that apply to your community include the public policy prohibitions, which is the section of Kiowa that speaks to certain public policy restrictions, including the ability to run a home-based business or to install fire mitigation around the unit owner's property. There's also public policy prohibitions on flags and signs, and also accessory dwelling units, ADUs. So that's all section 106.5. Also, the amendment of the declaration applies to pre-Kiowa communities. The ability to adopt budgets, which is section 302. Enforcement of covenants and rules. Pre-Kiowa communities are subject to the annual disclosures requirement found in Kiowa, which is a set of documents, financial documents, and other records that the association must disclose to the unit owners annually. And lastly, responsible governance policies as set forth in 209.5. Hopefully, if you're on this call, you know what those responsible governance policies are. If not, you're in luck because I will list those here in a little bit. So for pre-Kiowa communities, what are some notable exclusions for portions of Kiowa that do not apply to pre-Kiowa communities? The first one is going to be essentially a lot of these have to do with like the creation and formation of the community when it was initially created, right? So if your community was created in say 1983, I guess the appetite of the state or the legislatures and various stakeholders was to determine, hey, you know, it's kind of hard to apply these new laws to communities that have already been created and where the work has already been done. So these exclusions therefore apply to these pre-Kiowa communities. Creation of common interest communities, section 201, in addition to termination of common interest communities. For these earlier communities, for these pre-Kiowa communities, they are not subject to Kiowa's provision concerning an association's power to assign future income. When I say, you might ask, what does that mean? What is the ability to assign future income? Essentially, that is an association's ability to apply for and secure a loan from a bank or financing. So banks typically will look at the cash flow of the association in terms of assessments collected by the unit owners. So pre-Kiowa communities do not enjoy this privilege. Now, that's not to say that your pre-Kiowa community might have this provision in your declaration. That likely just means, if it does, that likely just means at some point in the past, your declaration was amended to adopt these powers. There are certain limitations of liability for directors, which Kiowa provides that directors are not held liable as long as their decisions are not made willfully or wantonly, as well as certain insurance provisions, including waiver of subrogation, which relates to an association's ability to levy or issue as far as the proceeds from an insurance claim goes, the ability of the association to collect from a negligent homeowner or issue deductibles toward unit owners who might have benefited from those insurance proceeds. Okay, so so this is kind of going into more of those sections that do not apply to pre-Kiowa communities. I think I spoke to about most of these. Powers to deal with the declarant includes the association's ability to move forward with their own management company, perhaps, or with their own vendors, whereas pre-Kiowa communities may have had to stick with the declarant's property management company for a set period of time. Yep, and then moving right along here. So, so you might be asking, you know, other than the year a community was built, there are also certain considerations that should help in determining whether your community is a pre-Kiowa community, including the date. Well, of course, the date in which the community was created, the type of community, whether it's a co-op, a condo, or a planned community, and the size of the community, including the amount of expenses that the community incurs. Okay, so I think it's important to notate here that both, notwithstanding whether your community is pre-Kiowa or post-Kiowa, all communities must have the 9 good governance policies. And this is set forth in Kiowa. So hopefully you know what these good governance policies are. If not, hopefully this should help you out. So the first policy is the collection of unpaid assessments, naturally. So a policy that sets forth what happens in the event that a unit owner is delinquent or doesn't pay their assessment, and the association's power to perhaps work with a collections company or an attorney, a collections attorney, to pursue those delinquencies. So that's policy number 1. Policy number 2 is the handling of conflicts of interest involving board members, which at a minimum has to define when a conflict of interest might exist. And in most cases, if a conflict of interest does exist with a director, perhaps that board member should recuse themselves of voting on an issue where there might be a perception of a conflict of interest. The policy should describe those instances. There also has to be a policy on the conduct of meetings, which refers to how how should unit owners and directors behave in meetings? What are examples of good decorum? What are examples of bad or poor decorum? Probably the date and time when meetings should occur, and other various issues related to holding association and owner meetings. You might also see within the conduct of meetings policy something that speaks to whether meetings can be recorded and whether they should be held in person compared to online on the Zoom, on like a Zoom platform or some other online platform, and how is the association going to ensure that the unit owners are entitled to speak before an issue is voted on. It might be kind of difficult to figure out, does the association have the ability to mute owners or give them a set period of time to speak prior to muting them on Zoom, for example. The 4th policy is the enforcement of covenants and rules, including notice and hearing procedures and the schedule of fines. So ideally, this policy should include steps to ensure that enforcements aren't being selectively enforced and that they're being enforced in a fair and transparent manner, as well as when a hearing is when an owner has the right to a hearing regarding any alleged violations. The next policy is the inspection and copying of association records by unit owners. So this policy should ideally refer to Kiowa section 317, and the association might have its own set of records that the owners are entitled to. The investment of reserve funds. So if there are any reserve funds, which hopefully your community should be meeting its reserve fund investment goal, or funding goal, not investment goal. How may the board members or how may the association invest those reserve funds? It might not be the best idea to invest in cryptocurrency or Bitcoins, as those pose typically a greater risk than more low risk investment vehicles, say like a certificate of deposit or a FDIC backed savings account. But that policy will set forth those restrictions. Procedures for the adoption and amendment of policies, procedures, and rules. So how the community can move forward with amending or changing the policies or procedures. A lot of times we see board members or directors having this power from a majority vote, but sometimes owner approval might be required. Number 8 here, procedures for addressing disputes arising between the association and the unit owners. So whether it's recommended or encouraged or required that the unit owner submit their complaint in writing, and perhaps how long the board has to offer a reply, as well as any suggested mediation, steps for mediation or arbitration, or kind of a good faith effort to attempt to resolve the dispute prior to litigation. And then the last policy here is essentially when a reserve study shall be prepared or conducted, whether there's a funding plan for any of the work recommended by the reserve study, and the projected sources of funding for the work. So those are the 9 good governance policies. And if your association doesn't currently have those policies, it might be a good idea to speak with legal counsel to help you in preparing those policies. At the very minimum, conversing with your fellow board members to ensure that these policies are in place and that they make good sense for your community. Okay, so kind of going back to pre-CCIOA communities. So now that we sort of have an idea of some of the provisions that do apply and don't apply to pre-CCIOA communities, pre-CCIOA communities, or I guess I should say CCIOA, grants pre-CCIOA communities or certain other exempt communities, including small and limited expense plan communities, to opt in to CCIOA. So why might a community decide to opt in to CCIOA? I put 5 reasons here, including the allocation of voting privileges, rights and duties concerning common elements, requirements for the maps and building plans, alteration and subdivision of units, and any easement rights. So perhaps your community, if it's pre-CCIOA, would like to strengthen or incorporate some of these provisions into your declaration. And this could be a good reason why your community might want to opt in to CCIOA. I will say, by no means is this presentation a sales pitch for CCIOA. It's just intended to be hopefully an understanding of pre-CCIOA and CCIOA communities and the ability to opt in. So if the community does decide to elect for treatment of CCIOA, there is a procedure to follow that's set forth in CCIOA, and that's found at section 118. So a vote has to occur at a meeting of the owners where quorum has been achieved. Quorum must be achieved at this opt-in meeting. Proper notice must go out to the owners, informing them of the association's intent or desire to be subject to CCIOA. And the notice also must include a current and complete copy of CCIOA. That's a lot of paperwork, I do realize. I do not think the statute contemplates by what method the association has to send out a copy of CCIOA. However, I think a very good idea would be to send it electronically, because that would be a lot of pages to print and mail. 67% owner approval is required at the meeting. I'm sorry, I should have clarified that a little bit better on the slide there, but 67% owner approval required at the meeting where a quorum has been achieved. So a statement of election has to be recorded with the county clerk and recorder's office. When you're considering, is there any benefit or advantage to exercise this right compared to just simply amending your declaration to come into conformity with Kiowa? This might be an easier way to elect for treatment of Kiowa because the threshold is lower with this method compared to the threshold which is required to amend the declaration. So for opting in or for electing treatment only requires 67% of the owners who are present and entitled to vote at that meeting where quorum's been achieved, compared to amending the declaration, which requires 67% of all the owners in the community, not just those who are present at the meeting. As I mentioned, there are other types of communities, not just pre-Kiowa, but certain other types of communities that are exempt from Kiowa. The first being a cooperative or planned community. Note, this does not apply to condominiums, but only to cooperatives or planned communities. If the cooperative or planned community was created on or after July 1st, 1992, and either contains only units restricted to non-residential use or contains no more than 20 units and is not subject to any development rights. Or Kiowa also exempts many portions from planned communities if the planned community provides in its declaration that the annual average common expense liability of each unit is each unit restricted to residential purposes must not exceed $400. These are the assessments. Annual average common expense liability would be the assessments or the dues, as adjusted annually since July 1st, 1999, for changes in the consumer price index. So these are considered limited expense planned communities. Kiowa does not define or acknowledge limited expense condominiums, but only planned communities. And these are also communities that need to increase that cap every year according to any increase in the consumer price index. So for these types of communities, they're only subject to Kiowa sections 105 through 107. 105 through 107 includes that public policy prohibition section that I mentioned earlier. And if you would like more information, you can refer to section 116. All right. So these types of communities, the limited expense and small planned communities, may choose to subject themselves to Kiowa by adopting an amendment to their declaration evidencing its election. And that process would be followed from section 116, subsection 4. And I think I already went over this. This might be a somewhat duplicated slide, but essentially it's explaining the small limited expense plan communities, including certain types of fees that might calculate into the annual cap, as well as the which area to follow when referring to the consumer pricing index, which is the Denver-Boulder Consolidated Metropolitan Statistical Area. And that is determined if you've never heard of the consumer pricing index, or if you're not sure which government entity publishes that information, that is the U.S. Bureau of Labor Statistics. All right, and So previously, this office has hosted a community association attorney. I think it was back in 2021. Vile Fotheringham LLC graciously joined us and helped us with a presentation explaining the applicability of Kiowa to common interest communities, and they did provide this flow chart, which I found to be particularly helpful in trying to understand whether Kiowa applies to your or to any community. I won't go through the entire thing. If you're watching on YouTube after the fact, of course, you can just pause it or take a screenshot. I'm also happy to email you a copy of this document. But essentially, you'll figure out, whether there's a declaration, whether there's real estate described in it. It'll ask you to consider the number of units in your community, the date the community was created, whether there's any cap on assessments, whether it's considered a large planned community as defined by Kiowa, and the result will be the specific statutes that apply to your community. So recent legislation has passed that relates to this topic, and that would be Senate Bill 24-021, new cooperatives and small and limited expense planned communities notification. So there's a good chance that your community received a notification from this office, providing you with further information on how the law was changed to sort of consolidate these restrictions or exemptions. So current law allows certain cooperatives and planned communities to claim an exemption from most of Kiowa, provided they meet the specifications outlined in section 116. And the new law expands the number of communities that may claim this exemption. And I believe it increased the threshold from 10 units to 20 units. The new law states that communities that meet the following requirements may qualify as a new small cooperative or small limited expense planned community. I think the intent of this legislation was to simplify the regulatory compliance burdens for some of these smaller limited expense communities. So if it's the desire or appetite of the community to take a look at which laws may apply, they can claim this exemption. I did put some scenarios there, which may assist your community in determining if this exemption applies. I won't read those word for word, but also happy to send you a copy of this if you would like. All right. Okay, moving right along here. So there was also legislation, while not super recent, was about 7 or 8 years ago, House Bill 18-1342, which allows pre-Kiowa communities, unit owners or members to veto the homeowner association budget. The legislature, the General Assembly, likes to use the word homeowners association, although we've come to find that that's not legally defined. But essentially, this applies to common interest communities, pre-Kiowa as well as, of course, post-Kiowa. So this bill mandated that all pre-Kiowa communities follow the budget veto process found in Kiowa Section 303, which essentially requires or provides that a budget summary must be mailed out to owners within 90 days after the board adopts a budget. The association must set a date for the budget meeting to occur. The date has to be in a reasonable amount of time. Unfortunately, Kiowa doesn't define reasonable amount of time. Also, this provision must allow for a majority of all the owners or any other larger percentage that might be specified in the declaration an opportunity to veto the proposed budget. So, as you're on this call, maybe some light bulbs went off, or some considerations on maybe it would make sense for your community to opt in or elect for treatment of Kiowa. These are some perceived advantages that may apply to help in making this decision. So currently, you will certainly want to review your declaration and understand what it currently says about whether your community is subject to Kiowa or whether there are certain exemptions. Also, you'll just want to kind of gather these sentiments in your annual owners meetings and board meetings about just what do people think about the community, and either granting or removing more or less power from the association. Perhaps maybe your community is more pro HOA. Essentially, do we want to give more power to the board to enforce covenants? Maybe we want to more aggressively pursue delinquent unit owners, compared to, well, maybe we don't want the association to have so much power, and not be subject to Kiowa in that extent. So one question to consider would be, are the rights and responsibilities that are enumerated in Kiowa, do they stand to benefit or harm your community? So that's a question that has to be answered by the members of the community. So what about registration? So all common interest communities must register. That is a statutory requirement found in Kiowa. All pre-Kiowa communities must register, and that requirement is found at section 117, 1.5N. While Kiowa doesn't expressly state whether small and limited expense plan communities must register, it is the division's position that all associations should register. Section 401 does state that the right of an association that fails to register or whose annual registration has expired to impose or enforce a lien for assessments under section 316, or to pursue an action or employ an enforcement mechanism is suspended until the association is validly registered. So currently the division has almost 12,000 registrants, including a wide variety of common interest communities, condominiums, cooperatives, HOAs, property owners associations, road owners associations, pre-Kiowa communities, Kiowa communities, and limited expense communities. If you'd like to check the registration status of your community, we do encourage you to visit our website. And just kind of wrapping up here, these next slides, I thought it'd be helpful to include a comprehensive list of Kiowa provisions that are applicable to pre-Kiowa communities, as well as provisions that are not or inapplicable to pre-Kiowa communities. I'm not going to go over every single one of these, but hopefully this list should help aid you in trying to figure out which law applies to your community and which law doesn't. So it's a pretty comprehensive list. So everything under the green header here, these sections will apply to pre-Kiowa communities. Again, that's the, if I can get my laser pointer here, the prohibitions contrary to public policy section. Eminent domain, that speaks to what happens if the government takes over the property. Applicability to pre-existing common interest communities, how to elect for treatment, some of the exceptions found for small and limited expense planned communities, legislative declaration for the encouragement of alternative dispute resolution. Importantly here, you have section 2094 and 5 regarding the annual disclosures and the responsible governance policies, as well as executive board member education and owner education. Kiowa does mandate that the association provide education to the owners without cost, without charge on an annual basis. The board may decide amongst itself what sort of education to provide, but it should reference Colorado law and Kiowa. Organization of Unit Owners Association and meetings all apply to pre-Kiowa communities. And of course, you do have sections that are only partially applicable. So you'll have to check that section individually to determine, you'll have to check section 117 to determine which portions of these sections apply to pre-Kiowa communities. And then kind of lastly, you have your assessments for common expenses, liens, association records, and then of course the registration requirement. So kind of moving through what are not applicable. It includes contents of the declaration, which I went through in detail earlier. The creation of the common interest community, as well as the unit boundaries and plats and maps. Exercise of development rights, subdivision of units, termination of the common interest community, as well as master associations and the relationship between the master association and the sub-association, merger or consolidation of two common interest communities, some various other provisions here that are not applicable to pre-Kiowa communities, and kind of concluding with part 3 of Kiowa regarding quorums, the conveyance or encumbrance of common elements, as well as what to do in the event that there's surplus funds of the budget, and what must happen in the event that the association has surplus funds. So that concludes my presentation today. I have not had my Q&A box pulled up. Hopefully I'm still presenting at this point in time.
You are. This is David. There's currently no pending questions in the Q&A line, but I just wanted to point out a few things real quick for you all, the viewers. It's always helpful for you to keep the Q&A open yourself, because there are some great questions in there. A couple questions in particular came up this time. Of course, one being, can you get a copy of these slides or view this recording later? Can you send this a copy for maybe another board member to watch, something like that? Yes, we do record all of our meetings, our HOA forums, and they can be viewed on our website. If you need the link, please take a look at that Q&A, because that's the easiest way, rather than me trying to spell out the entire URL, the web address. The other thing that we had a couple questions about this time, Nick, were questions about the legislative session in general, because as you know, there are lots of changes to Kiowa. Almost basically every year there are changes to Kiowa. And so I just wanted to drop a line to everyone to help them understand, yes, Kiowa can be changed by the legislature during the legislative session, which traditionally starts in January and ends in June of each year. Actually ends in May, excuse me. But however, the HOA Information Office provides legislative summaries as well as a forum on the changes from that year. Usually in June of or July of each year, we will provide that forum. Once this session has finished up, we want to keep you up to date on what the latest changes are. And so again, visiting our recent HOA forums would be a great place to see what the laws were that changed this year. And an important follow-up to that last point is that the legislature takes some time to get the newest laws. So I know that we'll start getting lots of questions from the public in the next little while about, can I get the latest version of Kiowa? And although we do have that on our website, the legislature has not released the latest version of Kiowa with the new bills that were passed earlier in 2026. They have not passed or released that yet. Traditionally, that's going to be released around the early to mid October, and so that's a great time to reach out to the our office or to visit our website and download the latest version of Kiowa. But laws that were passed in January, February, March of 2025 aren't going to be reflected in Kiowa until October. It's just the nature of the beast. It takes a long time for all of the laws in the Colorado revised statutes to be updated with everything that gets passed each and every year. So that's a busy job that the Office of Legislative Legal Services has. But keep an eye out for that. And with that, I'll pass it back to you, Nick, if there's any other questions you see that you'd like to touch base on.
I was going to make one point on something you just said there, David, regarding how frequently the legislature amends Kiowa. Sometimes it can be difficult to figure out specifically what section. Well, when you look at a bill, for example, when you go to the General Assembly website and perhaps you're interested in a bill that would change certain collection procedures in common interest communities. I'm just giving an example here. So you'll open up that bill and you'll scroll down and you'll see all the various language that will be modified or amended. Sometimes the bills don't always relate just to Kiowa or just to an issue, a perceived HOA issue. You might only see like the last 10% of a bill will relate to Kiowa. And how to check that or how to confirm that is if you look at that section in the bill, right above the section number or the site should be a paragraph explaining which section of the CRS this language is modifying. So it'll say this language adds to, it won't say Kiowa, it'll say Title 38, Article 33.3, section, etc., etc. So it's important to understand that these bills do not specifically identify Kiowa, but they will actually reference the CRS. If I go back to my slide that I thought I had something on that, the title, article, and section. I know I had a slide that clearly identified that, but yeah, make sure you pay when you're looking at these bills. Make sure you pay attention to the explanatory paragraph that describes how specifically the Colorado revised statutes are being added to or amended to, or sometimes stricken or languages removed from that section. Yeah, that's all I was going to mention there. Thanks, David. But yeah, let's see.
Just one more question. A real good question just came in a moment ago. Is what is the applicability of Kiowa to metropolitan districts? And Nick touched on this in his presentation, but metropolitan districts are legally a distinct and different type of organization. First and foremost, they are quasi-governmental organizations. So for instance, the Colorado Open Records Act applies to them. They are acting in the same way that a city government would in many respects. And metropolitan districts are governed by Title 32 of the Colorado Revised Statutes, not Title 38, like common interest communities like HOAs and condominium complexes. So although there are lots of similarities, and it's very understandable to confuse the two or think that the two are the same, they are legally different. So just wanted to help clarify that.
All right. Well, this concludes our HOA forum for August. We do look forward to our topic for next month, where we will be hosting a community association management company, and they will speak a little bit about some considerations of being self-managed versus a professionally managed common interest community, and sort of some best approaches on working with a community management company. So we're looking forward to that next month. And with that, I hope everybody has a great Labor Day weekend. And yeah,